Number 50, Sinai Goddard versus Lydia Hubbell.
Everybody involved in this matter, please come forward. All right, Ms. Hubbell, raise your right hand. Face my court officer, please.
Solemnly swear or affirm the testimony about the court, the truth, the whole truth, and the
I
truth, so help you God.
do.
All right, Ms. Hubbell, tell me what you're asking the court to do. You are the respondent in this matter, is that right? You were the person against whom the order of protection was being sought?
Yes.
All right. What are you asking me to do today?
I would like to have you reconsider your decision, and most importantly, I would like for you to remove my daughter from the order of protection. I have I brought some evidence today that I think you should consider, and also I would like to I'd like for you to reconsider it altogether, because my daughter's been over 120 days without seeing me. She was for her whole life, I was a primary residential parent, and her dad decided that when she was old enough to go to school, he was going to take her out of my life, and that's what he's done. I haven't had any money for an attorney.
Well, Ms. Hubbell, now, I went back and got the narration on this about what allegedly happened, and now I remember this case. You say he took the child out of your life, but this behavior is outrageous. I mean, you go around beating on the doors and windows of his home?
Your Honor, he was lying, and I have a copy of the emergency call.
But we had a hearing on that.
Yes, we did, but he was lying.
Well, as far as the court's concerned, I heard what there was to be heard, and I found there was a basis for some sort of protection. The most the court would possibly do would be considering allowing you to have some parenting time. But, you know, to be real honest, I'm not so sure that I wouldn't want you to have some type of an evaluation before I do it. I'm not going to put this. How old is this child?
Her birthday was yesterday. She's 7 years old.
I don't know that I'm going to put a small child in the possession, even if it's for a little bit, of a person that I'm concerned about their judgment. I mean, your judgment in this seems to me to be pretty terrible.
Well,
he claims they're harassing him, multiple telephone calls.
as you said, it's the bite of the whoever gets to present their proof first. They've lied from the beginning. I've got proof that he lied to you, and it is true I went to his house, but it's not true that I've disregarded all of the orders in the juvenile court. It's not true that they didn't have...
why would you go to his house? Wasn't he exercising parenting time with the child?
What happened was...
All right, listen to my question. Wasn't he exercising parenting time with this child?
Yes, he was.
You ought to just exchange the child, and then you follow him over to his house.
No, I did not. I did not follow him to his house.
You didn't go to the house when he had the child there. He'd just gotten the child that day, correct?
We had... Well, I had just dropped him...
Excuse me. He had gotten the child that day.
Yes.
And then you're over there within a relatively short period of time beating on the door.
I was not beating on the door.
Okay.
We
can all disagree about that, but that's what the court found.
Well, that's what he swore in his affidavit, just like he's sworn in many affidavits, things that I've got proof that he's lying about. Mm-hmm. He told you that my daughter, the reason I was the one that was respecting the court order. We had joint decision-making authority, and I was supposed to be able to exercise parenting time with my daughter during the summer, and I had right of first refusal. If he signed her up for a summer camp, I had the right, as her parent, who has priority over third parties, to have time with that child. I could have gone and picked her up. He could have dropped her off. I could have picked her up and had her for the day and then dropped her off with him for his parenting time. But I didn't want to do that. I wanted to get one.
Let me advise you, ma'am. I'm not going to change this. It's probable that I'm not going to change this at all. On the other hand, I'm sure not going to change it without the father being here. I don't know why he's not here. I'm concerned that he didn't get proper notice on this.
I hand-delivered the notice to his attorney on Monday. He's delaying this. Sarah Rice.
All right. I don't know that Ms. Rice still represents him. When did you give him the notice? And when did you give her the notice?
Monday. They were supposed to be here
Monday of this week?
Yeah, actually it was last Friday, because I was trying to schedule this. And I don't...
Well, here's the point. The reason when you file a motion, it's heard 2 weeks later is to try to give people an opportunity. This says that it was a certified copy foregoing motion by fax to the Davidson County Sheriff's Department. So what is his connection with the Davidson County Sheriff's Department?
What he has done is...
Listen to my question. He's not a deputy sheriff, is he?
I'm not sure what that is, but I can tell you what he's done.
What does he do for a living?
He's a computer programmer. He's got his own business. He works from home.
Well, then you know he doesn't work for the Davidson County Sheriff's Department. Do you know why this was faxed to the Davidson County Sheriff's Department?
Well, I'm trying to tell you what he did after the night I went to his house.
That's neither. Excuse me, ma'am. That's neither here nor there.
Well, you're just asking me. I'm not sure what he had me.
Stop talking, please, for just a second. The purpose of a motion is whether I would alter or amend this order. I'm not going to set aside the order of protection. I would consider you having some parenting time. Have you been under the care of any type of counselor or psychologist in the last 6 months?
I have been under therapy for 4.5 years to help me deal with this abusive relationship with my daughter's dad. Yes, I was there last Friday, as a matter of fact.
Who is your therapist?
John Lewis. I have a letter from him that he emailed to.
And do you know what his education? Psychologist, psychiatrist? You know what?
Psychiatric nurse practitioner.
All right.
And I have a copy of a letter that he emailed to Sarah Rice back when this all started. This is dated June 27th. He said he's been seeing me since May 7, 2011. He said I've been exceptionally compliant with treatment. I'm a devoted and caring mother, and he's seen me on multiple occasions with my daughter. And I'm a competent, nurturing parent that shows no overt limitations in her ability to raise Delara. He says I further see her as capable.
Listen to me carefully, Ms. Hubbell. I'm going to reset your motion for 2 weeks. I'm going to issue an order requiring both you and Mr. what's his name, Gilder, to be here on that day. That'll be the 30th.
October 30th?
October the 30th. And the court is going to give you an opportunity if you can get your counselor here, if you can get a current letter from him saying you don't represent a threat of harm, that you'll comply in his opinion with all court orders. I will give you an opportunity to put on that proof, and I'll consider giving you some parenting time with this child.
Okay.
But please listen to me. I'm not going to tolerate this sort of behavior. So whatever adjustment you need to make in your thinking pattern, you need to make that, because if I did that and something like this were to happen again, just kiss it goodbye. I'm not going to put a child in a tornado, and that's what this sounds like to me.
Well, as I said, it was misrepresented.
I understand that you feel like the court made the wrong decision, but I heard what I heard, and in my opinion, that his testimony was consistent with what he put in this, and there was no reason for you to be at that man's house while he's trying to exercise parenting time. You want to dispute that, all you're doing is making your situation harder. If you think it's okay for you to come to the other parent's house anytime you want to.
I never did do that. I never
You
did.
weren't even there.
No, I was there
Okay.
because I was trying.
Don't say anymore, because all you're doing is making the situation a little worse.
Can I?
No, ma'am, we've done all we're going to do.
Okay, referring to this letter you said.
Come back October the 30th and try to get something from your therapist that says he believes you'll be compliant with the court's orders, that you can properly take care of the child, that at this stage you would not harass or stalk the other party in this case. Those are the things I'm concerned about.
Okay. So you wouldn't consider that if I brought in a signed letter, you wouldn't consider that? I mean, I know they would object to it as hearsay.
We'll have to see.
Okay, so you would be willing to overrule their objection if I have
I'll be willing to consider it, ma'am.
Thank you.
Now, Ms. Barnes, Ms. Hubbell, write down on a piece of paper your mailing address. We're going to mail you a copy of the order setting this.
Okay.
So, I'm going to be sure that we've got your exact mailing address in your handwriting so that we can send you a copy of this.
Okay. And can I tell you what happened in juvenile court?
You can.
So we're going to be back in 2 weeks.
2 weeks.
Thank you.
She says Mr. Freeman no longer represents her, so we'll do our own order from today's hearing, where she said Mr. Freeman doesn't represent her, and we'll get a copy of all of this from Ms. Rice so that she can notify her client. Ms. Hubbell, come back in 2 weeks. We'll see if we can do anything for you, okay?
Thank you.
All right, thank you. Have a good weekend. All right, do we have any other matters?